This video is not an easy for me to make. A client died, and it was a very sad event for me. We have built a relationship, attorney-client relationship, for over 9 months. We have had numerous conversations, probably 15. I usually tell clients to get a will right in the first 2 meetings and then follow up with an email. With this client, I don't know what. This client wasn't old or sick. This client was about 60 years old. And I told that client numerous times, did you have a will? Do you have a will? Because in his case, I felt that he was majorly taken advantage during the marriage, and there was some transfers he made that he shouldn't have and signed some Anyway, so the point is, I reminded him 10 times, and I am not an estate planning attorney. I told him, please find an estate planning attorney. He promised he will do it. He didn't. And then suddenly, out of the blue, a day after he asked me to have a meeting, he was in coma and passed away. Well, it turns out this client didn't have a will. So
this is still our house.
House at 2 Dearborn Drive and all belongings therein to Marta Cooper.
His wife would get everything because the presumption is everything is community. So without a will, the wife would get 100% community and half of separate property, and the other half the children would get. How do we know what's separate property? Well, typically when divorce ends, we have definition of what community is, and then we split it in half and give husband half and wife half, and that becomes his separate property. But then there is another thing. If husband can prove, for example, that before marriage and after separation, the money was separate property, then that money can be split 50-50 between the wife and the children upon death. Now, in this case, nothing was defined yet, which means the presumption is everything is community until the interested party, which could be the children, because there are no other interested party in the will, there is no will, they could come back and say, hold on a sec. We would like to litigate this case to determine what's separate, what's community. But the problem is, upon death, divorce completely terminated. So there is no way to litigate this. Which brings me to the next issue. The first thing you do, if you really don't want to get your other spouse everything, have a will. In divorce, there is an automatic restraining order, which means you cannot transfer, encumber money. But it doesn't say you cannot have a will, which means you can have a will and unfunded trust, which means you can create a trust agreement. You cannot put any money into that trust. But upon divorce, you can put the money, what's yours. So I strongly suggest to create a will. Now, since that client passed, what happens from a familial perspective? Attorney who represents the deceased client has to file, or the other side has to file a notice that the case has to be dismissed and attach a death certificate. And then this case is closed, and the attorney who represented the deceased client would have to return the remaining retainer only to the executor of the estate, not earlier. So there is no way that is allowed ethically to give money away to whoever calls first. I had a case actually where a long time ago, a client passed away, young client, jumped off the window, and the divorce just started. And his wife called me up first thing next day. How much retainer do you have? Can I have it? No, you have to have an estate executor to get it. So the moral of the story, to repeat it 24 times in this video, please have a will when you go through divorce and unfunded trust. I hope that was helpful. I will see you in my next video or in my consultation. Like, subscribe, Bye.